We've talked so many times about legal situations. By the time you need something, if you don't have it, it's too late.
Today, we're going to talk about the 5 legal documents that everyone needs. And we're joined by Jeff Barnett and Keith Leuty of Barnett and Leuty. They're lawyers. We're so excited to have you with us today to go over this and make sure that everybody knows all those documents that they need.
Yeah. Let's start with number 1. The biggest one I think that most people know about is the will.
Yeah. So, basically everyone needs a will. A will is a document that disposes of all of your property when you die. It also names somebody called an executor or an independent executor to administer your estate at the time that you die, and it basically round up any debts that you may have, and then distribute the estate according to the will's terms. If the person has minor children, then a will also names a guardian for those minor children and makes sure that there's somebody to take care of those kids after you're gone. So that's also a very important aspect as well. With a will, the probate process is very streamlined and very easy. And very predictable. My partner and I often use the analogy of a long, straight, well-paved highway that exists when you've got a will, and the exit ramps are all clearly labeled. You know exactly how much gas it's going to take to get from one place to the other, and everything is easy to plan and understand accordingly. If you don't have a will, then the probate process is kind of like off-roading, and it can be very bumpy. It can have a lot of detours. It can have a lot of roadblocks, and it takes a long time. When you have a will, the probate process is typically somewhere between 3 to 4 months. Mm-hmm. You can obviously stretch out things beyond that for distribution and whatever, but generally speaking, the court part is over in 3 to 4 months. If you don't have a will, easily exceeds 6 or 8 months, and sometimes goes on beyond a year. So it's definitely a more complicated and complex, also more expensive process because of all of that too.
Because every will has to go through probate.
Not necessarily. So, like if there are probate assets, if the person dies with assets in their name that need to be probated in order to transfer, then yes, any will like that needs to be probated. But sometimes people die having made a will in preparation for death. And it turns out that every account that they have, every real property that they have, transfers at death by some other means, and so there are ways to avoid probate. But it's always a good idea to have a will, because you don't always get those things done, and you don't always get those documents done or those preparations made.
I think that sometimes when people hear the word estate, getting your estate in order, they assume that you must have something. It must be a big thing. It must be a big estate with a lot of money. And a will is still really helpful, even if you don't have very much, right?
Right. I mean, most people wouldn't want to just leave behind and give to the bank or give to the state of Texas, $10,000, for instance. I mean, so, a will can help you obtain from the bank, that $10,000 or that $15,000, some kind of small estate, and obviously, for hundreds of thousands and for millions and whatever, as well. But absolutely small numbers, a house and $30,000. I mean, absolutely, you need a will for that, because you don't want to have to go through that more lengthy, costly, expensive process, especially when it's going to be disproportionately large by comparison to the amount of assets that are in the estate. You really want to make sure that those things transfer easily.
Yeah. Okay. One last will question. You mentioned the term executor. When you have several kids in the family, can that be a problem? Is it hard picking out who's going to be the executor?
And or how do you pick them?
Yeah, how do you pick them? Yeah.
Yeah, it absolutely can be. It can be complicated for some people. It can be super easy for other people. Sometimes you've got 3 kids, and all 3 of them are super intelligent, and they get it. it's something that they, and they're all fair and whatever, they'd all be good choices. And then that choice of deciding who's going to be first or who's going to be second is a tougher one. Sometimes it's more obvious. You've got someone that that is the business-minded person, the legal-minded person in your family, and then you got somebody who's a nurse or a doctor, and they'd be great for an agent on a medical power of attorney or something like that. So so then you can just divide the roles depending upon, and sometimes people the tiebreaker will be proximity.
Yeah.
Somebody lives in Maine and somebody lives right here in Austin. Somebody living in another state doesn't disqualify them by any means, but if they're equally as good, that can be a good tie-breaking factor.
Yeah, exactly. Well, you mentioned the term power of attorney. Let's talk about medical power of attorney.
Yeah, there's actually two powers of attorney that we consider everybody needs. One, of course, is the medical power of attorney. The other is called a statutory durable power of attorney, which means a financial power of attorney. But for the medical power of attorney, it's a person's opportunity to choose who they want to step into their shoes from a medical standpoint, should they ever be unable to make their own medical decisions for themselves for any reason, whether it's illness, injury, whether it's temporary, whether it's more permanent. But we encourage people to think of 3 or 4 people in succession. When you have a married couple, typically a spouse might be the first choice, followed by, if there's children, whichever child, like Jeff said, if one happens to work in the medical field, that might be a good choice for number 2. But the medical power of attorney tells the doctor who legally can step in to make those decisions. And whenever we're talking about a medical power of attorney, one thing that we want to mention to people is that these days it's very important that you also have what's known as a HIPAA release. Now, for us, we include it as part of our medical power of attorney. I know some attorneys choose to do that as a separate document, which is also fine. But the HIPAA release allows the person, the agent who's serving as the medical power of attorney, to access the medical records and information before making that decision. The other type of power of attorney, the financial power of attorney, once again allows a person to step into your shoes to manage your financial affairs, whether it's pay your bills, receive any debts. Sometimes it'll even involve signing deeds to transfer real estate, pretty much anything other than medical that statutory durable power of attorney will take care of. And the reason that it is so important, Jeff and I frequently talk about a person's estate or their affairs as being a big ball of yarn. Like if you pass away and you don't have a will, you're leaving a big ball of yarn to be untangled. Well, during your lifetime, if you are incapacitated in some way and you don't have the 2 powers of attorney in place, you have a big ball of yarn that is there for your loved ones to deal with. Because if you don't have the powers of attorney in place, the legal remedy, should you become incapacitated, would be guardianship. And guardianship is incredibly expensive, incredibly time consuming, and just something to be avoided if at all possible.
And it's not always a guarantee that you get it.
Yeah, it's not always a guarantee that you get it. It involves a lot of court dates, the court appointing an independent ad litem attorney. And so you can, 99% of the time, you can solve that problem and not have to worry about guardianship if you have your 2 powers of attorney in place.
And I think the one thing that I've learned that is, I think, really important, and a lot of times people miss, is the fact that, the will is for after somebody passes. The powers of attorney are for while they're still alive and being able to help with their care, whether it's paying their bills or making those medical decisions. If you want to be able to have a relationship with your parent's doctor, do you need that power of attorney or that HIPAA? Is that part of what's, if you want the doctor to be able to, if you want to be able to talk to them about, hey, I'm a little worried about mom, that kind of thing, do you need some of those documents?
Legally, the answer is yes. Now, in the real world, there may be doctors, especially if they know a family and they've been working with them for a while, that might answer some questions or give you a little bit of leeway. But, from a legal standpoint, yes, you absolutely do. And we also encourage people that we live in a day and age where it seems like, unfortunately, Alzheimer's and dementia is more prevalent than maybe it used to be. And if you have a loved one who becomes diagnosed with that there's a window of time where they're able to sign legal documents. And after that time period, you're going to be stuck. And so we encourage anybody, if you wind up getting a diagnosis like that, to put the powers of attorney first on your list of things to do while your loved one still has the legal capacity to sign them.
Okay, that's really important because, right, that's one of those, once you need it, it's too late if they're not able to
go back
and right.
Yeah. To me, maybe I'm the only one, a little bit of confusion about there's a medical power of attorney and a medical directive. Explain the difference between the two.
So the medical power of attorney is basically for, it appoints an agent to make medical decisions for the person who is no longer able to do so. The medical directive, which is a big, long formal name in Texas, a Directive to Physicians and Family or Surrogates. It's sometimes referred to as a living will, sometimes referred to as an advance directive, sometimes referred to as a medical directive. It's got lots of names, but it basically is the document that says, what you want to happen if you are, for instance, brain dead and the doctor has said, you're not coming back from that. Or, you've got some kind of a terminal, irreversible condition and you're unable to speak for yourself. Do you want, to be kept alive on a ventilator or a feeding tube for, years or months or whatever? Or do you want those things to be removed and allow your body to die naturally on its own? And that's really what the advanced directive, the Directive to Physicians is really all about. It's there for two reasons. One, it makes the doctors and medical personnel very clear about what your wishes are, but it also gives peace of mind to your family. Families sometimes really dread that for good reason. Oh gosh, I could never pull the plug on mom. I could never, do this. But if mom has said, this is what I want, it can really give somebody peace of mind.
Yeah.
And a do not resuscitate order, that DNR, that's part of that medical directive.
No, actually,
that's a whole other thing.
That's a big point of confusion as well. Very common. No, a DNR is basically a document that says, if you find me without a pulse, don't revive me. Don't give me mouth to mouth. Don't give me the paddles, whatever, do not revive me under any circumstances. If you're 25 years old and otherwise healthy and somehow you're found without a pulse, and they revive you, chances are you're going to be fine until you're 70 or 75 or whatever. They're going to live a long, healthy life. And so, therefore, somebody young or middle-aged and healthy, otherwise healthy, generally should not want a DNR. But on the other hand, anyone who is 20, 25, 50, whatever, should consider having and should have a Directive to Physicians.
So if somebody is interested in that DNR, if they have an elderly or an older parent, that's just a separate document that they need to take care of. Okay.
Yes, a DNR is a very useful tool, or can be a very useful tool if someone has maybe end-stage cancer, end-stage kidney disease, end-stage heart, they're already 95 years old or 100 years old, and they're just ready. That can be certainly an okay document in those kinds of scenarios. But if you're young or middle-aged and otherwise healthy, that's generally not one that you would want to have.
Okay.
And while the will and the powers of attorney both need the executor, someone that you're going to be naming probably from your family, medical directive is just you and your wishes.
That's correct. It does not name an agent to make that decision, because basically that document itself expresses the decision that you have already made in the present, right now in 2022, when I'm alive and competent. I am saying that if I ever satisfy these certain conditions, you can pull the plug.
Okay. Gotcha.
One more. We've mentioned 4, but there's a 5th. And this one's one that most people don't know about.
Appointment of agent for disposition of bodily remains. And it is a document that basically, like the powers of attorney, does appoint an agent. But unlike the powers of attorney, it basically it becomes active after you die, and it appoints that agent to take care of the disposition of your own body. It also expresses what you want your wishes to be, with regard to your body. Do you want to be cremated? Do you want to be donated to science? Do you want to be buried? Do you want to be buried? Do you want your memorial service or your funeral to be in the Catholic faith or the Jewish faith? Do you want to donate bodily organs and tissues for transplantation? Other kinds of things like that. And basically, like I said, it names an agent who actually takes care of all those decisions for you. Keith has got a great story of someone that called here at 5 o'clock on a Friday a few years ago. Tell them about that.
Yeah, that was one of those Friday afternoons when the office was empty, and I just happened to randomly pick up the phone. And the first thing that the person on the other end said was, "You got to help me." And I thought, now this is going to be an interesting phone call. I said, "What can I do?" And it was a nice young lady who said, "My brother and sister are down at the funeral home, and they're about to have my father embalmed." And I said, "And why is that a problem?" And she said, "Because my dad always told me he wanted to be cremated, and they're about to have him embalmed." And I said, "Well, do you have a disposition of remains document, or did he?" And of course, her response was, "A what?" And I said, "Well, dig around and see if you can find that, because that would solve the problem. That's what it's there for." Right. And I never heard back from her, so I guess maybe he didn't.
So, and actually, I guess if somebody doesn't have that document, would you need if you had that power of attorney, or is there anything you can do in that situation to do something different than what the funeral home is wanting to do?
Without that document, the next of kin is the person's natural line of the order, and so if the next of kin is a spouse, then there's nobody on that same level, and the spouse really gets to make that decision. Gotcha. Okay. And kids generally don't get to, at least officially, have a word in that. If there is no surviving spouse, then it's the kids. Okay. And as in the scenario that he just talked about, if two of them say one and one of them say another, or if there were 2 and 2, there can be a lack of clarity as to exactly what would happen. And of course, spouses and kids are more likely to know, how somebody wants to be handled. But if there are no spouse and kids, and it starts getting down into next of kin that are nieces and nephews or things like that, they may very well not know what you wanted at all, and so they may pick something that you don't really want to have happen.
So I really think that bottom line is having all of these documents just takes a lot of the guesswork out, right? That the decisions are made ahead of time, who's going to do what, that kind of thing, so that you don't have to either guess or have hopefully any disagreement over what the parents or the person's wishes are.
Exactly
right. And whenever we talk about the 5 legal documents everyone needs, Kim, we like to throw in one that maybe not everybody needs, but a lot of people need and they don't know it. Sort of a bonus here, and that's something called a ladybird deed. And ladybird deeds are a document that you sign either you sign while you have mental capacity to do so, or your power of attorney can sign it on your behalf. And that allows you to transfer ownership in your real estate upon your death immediately without the need of having to go through probate. So since Jeff was talking about the length of probate being 3 or 4 months and the costs involved, there is a way around that. And Texas is one of the few states that does have ladybird deeds. And so we encourage people to consider, if you do own real estate, to think about getting a ladybird deed in place, get it filed with the county where that land is, and then you can pass that real estate upon your death immediately and perhaps even avoid probate altogether.
Okay. If you're not in Texas, do you have options that are similar?
Every state is different. Some states have also what's known as a transfer on death deed, which Texas has now had for 5 or 6 years, I believe. You just have to check with your individual state.
Okay. Yeah. Now, at least you know the terminology that you're trying to pass along the property upon death without it having to go through probate.
Yeah.
Okay.
And we know that we have to clean up that ball of yarn.
That's right. That's right. And sometimes I think, so those are the 5 plus the bonus with the ladybird deed. a lot of times people will say, oh, I heard that I need a trust. How do you know? I know that's it's a bigger question, but is that just something that's so individualized depending on maybe what state you're in and or your parents' financial situation or your financial situation as to whether that's necessary, and really talking to an attorney is really the only way to figure that out?
You really just summarized what I was going to say. That's it really is very state dependent. There are some states like California that have very lengthy, complicated, and expensive probate systems. And in a state like that, basically everybody needs a revocable living trust.
Okay.
It can absolutely be useful in a state like Texas that has a more simplified, streamlined probate system, but it's much more fact dependent here.
Okay.
We definitely don't recommend it to everybody, but there are definitely circumstances where it can be helpful.
And there are different kinds of trust too.
Oh,
I mean,
yeah.
if you have a special needs individual, like a child, a supplemental needs trust would be essential. If you're trying to prepare for Medicaid, a Medicaid asset protection trust would be essential. So it is very case specific.
Very case specific.
Gotcha. Whew. My head's kind of spinning with all the different things, but hopefully this gives everybody just the ideas of those 5 important documents. And if they have one and not some of the others, that they need to that gives them the language and the ability to go ahead and fill in the gaps if there are any.
Figure out what they need.
Yeah.
Jeff Barnett, Keith Leuty, thank you so much for all these tips.
Our pleasure.
Thank you.
Yeah, it is a lot to think about and can be a little bit overwhelming, but certainly knowing the right words to use and the kinds of what things are called and what they do, I think is really helpful.
Yeah, and we've done a full interview with Keith about that Ladybird trust, so Ladybird deed. So if you have any other topics you'd like us to discuss here on Parenting Aging Parents, please let us know.